Hi, it's Sam Barker here from the Motley Fool. Behind me is Landmark Mall, or what used to be. What once was a bus Fool. Behind me is Landmark Mall, or what used to be. What once was a bus Fool. Behind me is Landmark Mall, or what used to be. What once was a bus Fool. Behind me is Landmark Mall, or what used to be. What once was a bus Fool. 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 Fool.
good,
He got it done.
the good.
He got it done.
Good morning. Can you hear me?
He got it done. We can hear you,
Good
Cassandra.
morning.
Good
Can you
morning.
hear me?
got
No,
it. We can hear
this
you,
is
Cassandra.
Valencia.
Good
Can you
morning.
hear me?
got it.
No,
We can hear
this
you,
is
Cassandra.
Valencia.
Good
Can you
morning.
hear me? Valencia. I'm
hear you.
Valencia. Can you hear me?
Yes.
Valencia.
All
I'm
right.
Valencia. Can you hear me?
need to, within that order, reference every single argument made before the court when issuing that order. What the court did was issue an order, and paragraphs 1 through 5 are general, reference every single argument made relief. The court. Paragraph 6 is when issuing. Did was order specifically issue an order, and paragraphs lays out what general reference specific relief needs to do to attain ballot access. Mr. Thornburg has done everything that's required of him in paragraph 6, and to go beyond that, and paragraph lays out. To change anything now would result in clear harm to plaintiffs who have relied on its terms. Mr. Thornburg relied on the terms of the order, did what he was supposed to do, and while Mr. Fogarty was an attorney before Ms. Pallmeyer for the case, he didn't raise this. If it had been raised there, presumably Mr. Fogarty would have said this is all moot because he pulled a primary ballot for a party. Whether that
He did do, right? That's uncontroverted that he voted in the primary.
if it had been raised
Right. I guess we have the record. Yeah.
but it wasn't raised then. So it wasn't raised then, and because of that,
He did do, right? That's uncontroverted that he voted.
there was no
in the primary.
ruling on that. What the ruling from
Right.
what
I guess we
the
got the
order
record,
stipulates is what he has to do in paragraph 6 to gain access to the ballot, and he's done so. So it's.
But how do you get around the prohibition of voting in the primary and
Because of
running?
that,
He did do, right? That's
Because
uncontroverted
the
that he voted.
complete on that. What the ruling from what the definite definition and the restrictions for ballot access for Mr. Thornburg are in paragraph 6.
But how do you get around the prohibition of voting in the
Judge's
primary and
order,
running?
that's what he has to do to gain access.
And back in April and May, in that libertarian case, when the number of signatures and the manner of collection was decided, I have no. On behalf of another candidate, I'm attempting to enter into that case, but I've not made any argument in that case as to eligibility. But the order is actually very clear. It speaks only to the requirements of section 10-4 being enjoined, not section 7-43. And then if you read the order carefully, yes, it does purport to afford Mr. Thornburg ballot access for any office for which he qualified in either 2018 or 2016, and he didn't qualify for any office in 2018 or 2016. So like the rest of the independent candidates, he had to collect signatures, which he did, and he has enough based on Judge Pallmeyer's order. But Judge Pallmeyer made no reference to the eligibility of any of these candidates. None of that was ever raised, and certainly I would put it back onto the plaintiffs. Had they believed or desired that they would have automatic access, no matter whether they're eligible or not, certainly they would have raised it before Judge Pallmeyer. No, the only things that were raised were the difficulty with collecting signatures due to COVID-19 and Governor Pritzker's executive orders. That's all that case applies to. Anything outside of those requirements are not addressed, and this candidate must still live up to all eligibility requirements. He has not, and so we'd ask that the objection be sustained.
Thank you. So, Ms. Melwitz, you're very familiar, of course, with Judge Pallmeyer's decision in the Libertarian case. I was aware only of the signature issue and the difficulty in gathering them, and not invalidating any of our other prohibitions. So would you agree with Mr. Fogarty on that?
I do agree with Mr. Fogarty. The paragraph that applies to Mr. Throneberg is very, very limited, and it would only give him any chance at ballot access without 10% signature requirement if he had run for that particular office 2 years ago or 4 years ago. It's not an automatic access provision that actually applies to him at all. So he is in the same boat and same situation as everyone else following the Libertarian order, and that he needed 10% of signatures, and he needed to meet the other requirements of the election code.
Thank you. Questions for members of the board? Member Hain? I think you got to unmute maybe, Bill.
What?
Uh,
Am I muted again?
Can you hear me
I
now?
think- Yeah, go ahead, Senator Hain.
Well, Judge Pallmeyer, with all due respect, is freely rewriting the Illinois election code. And now we're being asked by Councilor Erdman to infer a further rewrite when none exists, to basically read the judge's mind. This is another example of going beyond the statutory framework that we're obligated to uphold. We are a ministerial body. The judge did not address it, and the law is clear. It's got to be.
Mute microphone. I'm not hearing anything else.
Thank you. Other members that wish to be heard or have questions?
Mr. Chairman?
Yeah, Member Cadigan.
Yeah, I view this as sort of a fundamentally embodied in the election code is that you get one bite at the apple to be nominated to an office. And when the candidate voted in the Democratic primary and declared their intention to be a Democratic voter for this cycle and to attempt to file as an independent or an independent candidate, nothing about COVID changes that fundamental concept in the election code. So I agree with the recommendation of our general counsel and the hearing officer in this matter.
Thank you, Member Cadigan. Other members wish to be heard? If not, is there a motion regarding the general counsel's recommendation?
I'll make a motion that we adopt the recommendation of the hearing officer and general counsel and not certify the candidate for the ballot in the 2020 election.
Second.
Motion made and seconded. Roll call, please.
Mr. Cadigan?
Yes.
Ms. Donahue?
Yes.
Mr. Hain?
Rosen.
Yes.
Mr. McGuffich? Mr. McGuffich? Ms. O'Brien?
Yes.
Ms. Watson?
Yes.
Vice Chairman Littleberry?
Yes.
Chairman Schultz?
Yes. All right. The objection will be sustained and we'll adopt the recommendation that Mr. Throneberg will not be on the ballot. Go ahead, Ms. Malowitz.
The next case is Dart and Wagner versus McManaman, 20 SOE BGE 105. Objectors are represented by attorney Sherry Langenstein. Candidate is pro se. Objectors Kevin Dart and Donald Wagner filed an objection to the nomination papers of Kathleen McManaman, alleging that she filed an insufficient number of signatures. Staff count revealed the candidate filed 469 signatures, which was 839 signatures below the 1,308 required. Objectors filed a motion for summary judgment, arguing the insufficient signatures removed any questions of fact related to the candidate's qualifications. The hearing officer found, and I recommend, that the objector's motion for summary judgment be granted. the objection be sustained and the candidate's name not be certified to the ballot as a candidate for the 15th Congressional District of Illinois.
Thank you. All right, we'll hear from the objector first.
Good morning. This is Cherie Langenstein, counsel for the objectors, and I would just ask that you adopt the hearing officer's recommendation and sustain the objection.
Thank you. What about the candidate? Is the candidate on this call? McMahon, is the candidate on the call? I'll ask one more. All right, well, apparently not. Any of the board wish to be heard or have questions on this one? If not, I'd entertain a motion.
Make a motion that we adopt the finding of the hearing officer and the general counsel and find that the candidate not be certified for the general election 2020.
Second.
Motion made second. Roll call, please.
Mr. Cadigan?
Yes.
Ms. Donahue?
Yes.
Mr. Hain?
Yes.
Mr. McGuffich? Ms. O'Brien?
Yes.
Ms. Watson?
Yes.
Vice Chairman Littleberry?
No.
Yes.
Chairman Scholes?
Yes. All right, that objection will be sustained and the candidate will not be on the ballot. Go ahead, Marty. Hall versus Schluter.
Hall versus Schluter, 20 SOEB GE 106. Objector is represented by John Fogarty. No appearance was received by the candidate, Scott Schluter, but if he is present, he may address the board after my recommendation. Objector Ricky Hall filed an objection to the nomination papers of Scott Schluter, alleging he filed an insufficient number of signatures. A staff count showed that Schluter filed 133 signatures, which is 90 below the minimum required under Article 10 as modified by the Libertarian Party preliminary injunction order. The hearing officer found, and I concur, that the candidate submitted fewer signatures than required, and as such, the objection should be sustained, and the candidate's name should not be certified to the ballot as a candidate to the General Assembly for the 117th Representative District of the state of Illinois.
Thank you, Ms. Malowitz. Mr. Fogarty?
We would ask for adoption of this report. Thank you.
Thank you. And we'll ask for the candidate. This was posted as a public meeting. If the candidate is attending via Zoom, this is your chance to speak. All right. If not, the board will take it up with any questions or comments from members of the board. Seems like a pretty straightforward signature case. Yes. Was that member Cadigan?
Yeah, I'll make a motion that we adopt the recommendation of the hearing officer and general counsel that the candidate's name not be certified to the ballot as a candidate for nomination to the office of representative in the General Assembly.
Second.
Motion made second. Roll call, please.
Mr. Cadigan?
Yes.
Ms. Donahue?
Yes.
Mr. Hain?
Yes.
Mr. McGuffich?
Yes.
Ms. O'Brien?
Yes.
Ms. Watson?
Yes.
Vice Chairman Littleberry?
Yes.
Chairman Scholes?
Yes. All right, that objection will be sustained. Hall v. Graff.
20 SOEB GE 107. The objector is represented by John Fogarty. The candidate is pro se. Objector Ricky Hall filed an objection to the nomination papers of Ellen Graff on the basis that the candidate failed to file a statement of economic interest, did not file the minimum number of signatures, as those signatures that she did file contained material defects. The candidate filed a motion to strike and dismiss the paragraphs 4 and 5 of the objector's petition regarding the filing of the receipt of the statement of economic interest. The objector conceded that the candidate timely filed the receipt for her filing of her statement of economic interests. A record examination was conducted and resulted in the candidate having 10 fewer signatures than required. The hearing officer recommends, and I concur, that the candidate's motion to strike and dismiss be granted in part and denied in part, striking paragraphs 4 and 5, which relate to the filing of the receipt of the statement of economic interests. Further, based on the results of the record examination, it's recommended that the objection be sustained and that the candidate not be certified to the ballot for the office of representative to the General Assembly for the 117th Representative District.
Thank you, Ms. Malowitz. Mr. Fogarty?
Yes, we concur with the recommendation. Thank you.
Thank you. Ms. Graff, candidate? Does the candidate participate in this meeting? Ms. Graff, this would be your chance to be heard. All right. Hearing no response there, the board will take this up for any questions or discussion. If not, we'd entertain a motion.
Oh, Mr. Chairman, I'll make a motion that we adopt the recommendation of the hearing officer and our general counsel, and that the candidate not be certified for the ballot for the office of representative to the General Assembly.
Second.
Roll call, please.
Mr. Cadigan,
Yes.
Ms. Donahue,
Yes.
Mr. Hain,
Yes.
Mr. McGuffich,
Yes.
Ms. O'Brien,
Yes.
Ms. Watson,
Yes.
Vice Chairman Littleberry,
Yes.
Chairman Scholes.
Yes. That objection will be sustained and the candidate will not appear on the ballot. All right, agenda item F there, Ms. Malowitz.
Farshchi versus Haas, 20 SOEB GE 108. The objector is represented by John Fogarty. The candidate did not file an appearance, but if he is present, he may address the board after my recommendation. The objector, Mark Farshchi, filed an objection to the nomination papers of Alexander Haas on the basis that the candidate filed insufficient signatures. A staff count revealed he filed 56 signatures, which is 154 below the established minimum. The hearing officer found, and I recommend and concur, that the objection be sustained and the candidate not be certified to the ballot for the office of representative to the General Assembly for the 89th Representative District of Illinois.
Thank you, Ms. Malowitz. Does the objector wish to be heard from?
Yes, we would ask that the recommendation be adopted. Thank you.
Thank you. Is candidate Haas in the meeting here? Candidate Haas? All right, apparently not. It seems like another clear-cut signature issue. Is there any discussion or questions, or is there a motion?
I'll make a motion that we adopt the recommendation of the hearing officer and our general counsel that the candidate's name not be certified to the ballot for nomination of the office of representative in the General Assembly.
All right, thank you, Member Cadigan. Is there a second?
Second.
All right, roll call, please.
Mr. Cadigan,
Yes.
Ms. Donahue,
Yes.
Mr. Hain,
Yes.
Mr. McGuffich,
Yes.
Ms. O'Brien,
Yes.
Ms. Watson,
Yes.
Vice Chairman Littleberry,
Yes.
Chairman Scholes.
Yes. All right, that's objection will be sustained. Agenda item G.
Hardin versus Kuna Jacob, 20 SOEB GE 109. The objector is represented by John Fogarty. The candidate did not submit an appearance, but if he is present, he may address the board after my recommendation. The objector, Steve Hardin, filed an objection to the nomination papers of Thomas J. Kuna Jacob on the basis that the candidate filed insufficient signatures. A staff count revealed he filed 78 signatures, 126 below the minimum required. Based on the staff count, the hearing officer recommends, and I concur, that the objection be sustained and the candidate not be certified to the ballot as a candidate for the office of representative to the General Assembly from the 100th Representative District in Illinois.
Thank you, Ms. Malowitz. Is this the same candidate from agenda item A?
It is.
For a different office?
Oh, is it for a different office?
I don't know. I just was
Same
inquiring
office.
why we're seeing this
office.
twice. Same
it is
office?
the same office.
Oh, so it's just that we've ruled on in agenda item A? All right. Does the objector wish to be heard from?
No, we would ask that this be adopted as well.
All right. Mr. Kuna Jacob, are you on the call? Candidate Kuna Jacob, this would be your time to speak. All right. If not, questions or comments from the board? All right. If not, we'll entertain a recommendation on the, a motion on the general counsel's recommendation.
I make a motion that the recommendation of our hearing officer and the general counsel be adopted and that the candidate's name not be certified to the ballot as a candidate for the office of representative in the General Assembly.
Second.
Roll call, please.
Mr. Cadigan,
Yes.
Ms. Donahue,
Yes.
Mr. Hain,
Yes.
Mr. McGuffich,
Yes.
Ms. O'Brien,
Yes.
Ms. Watson,
Yes.
Vice Chairman Littleberry,
Yes.
Chairman Scholes.
Yes. All right, that objection will be sustained. All right, Ms. Małis, Collier versus Elmore.
20 SOEB GE 110. The objector is represented by Kevin Morphew. The candidate is represented by Pericles Abbasi. The objector, Jeffrey Collier, filed an objection to the nominating papers of Mark Elmore on the basis that if the Seventh Circuit overruled the Libertarian Party preliminary injunction order, which reduced signature requirements for this election, then the candidate failed to meet the statutory minimum signatures articulated in Article 10 and should not be certified to the ballot. Candidate filed a motion to strike and dismiss. Based on yesterday's decision from the Seventh Circuit upholding the Libertarian Party preliminary injunction order, I recommend that the objection be dismissed as moot and candidate's motion to strike and dismiss be dismissed as moot, and the candidate be certified to the ballot for representative to the General Assembly for the 80th Representative District of Illinois. I do note that this varies somewhat from the hearing officer opinion because of yesterday's intervening
I
events.
understand. Thank you. Mr. Morphew?
Yes, and this stands for the other 6 cases that are pending too. We stand on that recommendation. In light of yesterday's ruling, the objection is moot, and we have nothing further to add. Thank you.
Thank you. Mr. Abbasi?
I just request the board adopt the hearing officers or the general counsel's recommendation.
Thank you. Comments or questions from the board?
So, Mr. Morphew, are the objections being withdrawn in the other 6 cases?
I mean, if I'm not withdrawing them, I just haven't filled out the forms, but
Okay.
it's my position that the objection conceded that if the Seventh Circuit overruled or did not, overturn and they affirmed the preliminary injunction order, then the objection would have no basis, and that's occurred, and that's where we are.
Well, just for administrative purposes, can we dispose of these all now, Mr. Chairman, in one vote? And
That would be wonderful, wouldn't it?
And just
I mean,
reference
it's all the same issues?
the case name and number?
The one thing I would say is I do need a couple of separate rulings on motions to strike and dismiss, as those are also moot. So perhaps that motion can include that any pending motions to strike or dismiss also be dismissed as moot in addition to the objection.
Well, maybe the thing to do, Ms. Malowitz, is to sort of refer to the case name and number that a motion will apply to, and then provide us with a recommended motion that the board could then adopt. Would that be helpful?
Certainly. So case by case?
Yeah, just reference so the court reporter knows and the record reflects which case name and number the motion will apply to.
Certainly. So Pettit Senior versus Keating, 20 SOEB GE. You know what? We need to do this one first. So
Yeah.
Collier versus Elmore, 20 SOEB GE 110. The candidate's motion to strike and dismiss is moot. The objection should be dismissed as moot, and the candidate should be certified to the ballot. Pettit Senior versus Keating, 20 SOEB GE 111. The objection should be dismissed as moot. The candidate's motion to strike and dismiss be dismissed as moot, and the candidate be certified to the ballot for representative to the General Assembly for the 96th Representative District of Illinois. Collier versus Music, 20 SOEB GE 112. Based on the Libertarians' decision from yesterday, I recommend the objection be dismissed as moot, that the candidate be certified to the ballot for representative for the General Assembly for the 113th Representative District of Illinois. Riley versus Grimm, 20 SOEB GE 113. I recommend that the objection be dismissed as moot, the candidate's motion to strike and dismiss be dismissed as moot, and the candidate be certified to the ballot for representative for the General Assembly for the 92nd Representative District of Illinois. Next, Williams versus Ballot, 20 SOEB GE 114. I recommend that the objection be dismissed as moot, the candidate's motion to strike and dismiss be dismissed as moot, and the candidate be certified to the ballot for representative to the General Assembly for the 103rd Representative District of Illinois. And that is the last one in that subset.
Okay. Mr. Morphew, you understand what's going to happen with these 6 cases and based on your remarks in Collier?
Yes.
Okay. And Mr. Abbasi?
So I'm representing in 4 of those cases, but for my 4, I do ask the board to adopt the recommendation of the general counsel.
All right. Thank you. Who was not represented out of those 6?
The candidate in the music case never appeared,
Okay.
but the recommendation was still that the candidate appear on the ballot. And then I believe Mr. Mastrangelo is representing the candidate in the Keating case.
All right. In candidate
Chairman,
music? Yes, go ahead.
Can I ask General Counsel, could you summarize briefly the Seventh Circuit's decision here?
Certainly, as it's relevant to here, the Seventh Circuit affirmed the preliminary injunction order. So basically the order is still in effect and binding for this election. It was the Seventh Circuit's opinion that the board consented to the entry of this preliminary injunction order. And therefore we did not have the ability to contest it.
Okay, thank you.
All right. So candidate Music, I'm going to ask you to, this is your opportunity to be heard. Hearing none. And then is there an attorney representing one of the other candidates here?
Yes.
I'm sorry, could you repeat that?
Mr. Mastrangelo is representing the candidate in Keating, I believe.
Okay. And you wish to be heard, sir?
Yes, sir, but only to ask the board to accept the general counsel's recommendation, and it's fairly consistent with what the hearing officer had recommended as well.
Thank you. All right. Any of the members of the board wish to be heard or have questions? If not, we're going to move on all 6 of these that are now moot because of the Seventh Circuit's opinion issued yesterday. Member Cadigan, were you about to make a motion?
I am. I make a motion that we adopt the recommendation of our general counsel as referenced earlier in the record here, as applied to all 6 of the cases that she referenced.
All right. Is there a second? Roll call,
Second.
please. All right. Roll call, please.
Mr. Cadigan,
Yes.
Ms. Donahue,
Yes.
Mr. Hain,
Yes.
Mr. McGuffich,
Yes.
Ms. O'Brien,
Yes.
Ms. Watson,
Yes.
Vice Chairman Lineberry,
Yes.
Chairman Scholes.
Yes. All right. Those candidates will appear. Where are we, Ms. Malowitz? Is it Turner or?
Turner versus Wilson, 20 SOEB
Okay.
115. The objector actually withdrew the objection yesterday, so we do not have anything to rule upon today.
All right.
We can call the next case, which is Morris versus West, 20 SOEB GE 501. The objectors are represented by Ed Mullen. The candidate is represented by Scott Erdman. Objectors Charles Morris, Sean Tenner, Denise Bradley, Steve Spagnolo, and Mitchell Johnson filed an objection to the nomination papers of candidate West on the basis that the candidate did not file the minimum number of signatures as those he filed contained material defects, and he failed to name a vice president in his nomination papers. The candidate filed a motion to strike and dismiss. A record examination was conducted and resulted in the candidate having 1,300 fewer signatures than the 2,500 required. The hearing officer recommends, and I concur, that the candidate's motion to strike and dismiss be granted in part and denied in part, striking paragraph 19, which relates to naming a vice president in nomination filings, as the statute does not explicitly require that a vice president candidate be named on an independent candidate's filings. Further, based on the results of the records examination, it's the recommendation that the objection be sustained and the candidate not be certified to the ballot for the office of President of the United States.
Thank you, Ms. Malowitz. We'll hear from the attorney for the objector. Is it Mr. Mullen?
Yes, thank you. We just asked that the board adopt the findings of the hearing officer and the recommendation of the general counsel.
Thank you. Mr. Erdman?
And we stand on the results of the records again. We have nothing else to add.
Thank you. Any questions from members of the board or discussion? If not, is there a motion regarding the general counsel's recommendation?
I'll make a motion that we adopt the recommendation of the general counsel and not certify the candidate for the fall election.
Second.
Roll call, please.
Mr. Cadigan?
Yes.
Ms. Donahue?
Yes.
Mr. Hain?
Yes.
Mr. McGuffich?
Yes.
Ms. O'Brien?
Yes.
Ms. Watson?
Yes.
Vice Chairman Lineberry?
Yes.
Chairman Scholes?
Yes. That objection will be sustained. All right, Morris versus West.
That was the one we just called, actually.
Oh, I'm sorry. Yeah, go ahead.
No problem. I'm actually going to call the next two cases together, Adams and Jones versus Pellegrini, 20 SOEB GE 502 and 503. The two objections are identical, with the only exception being the spelling of Ms. Pellegrini's name. I understand that the first objection had a misspelling and was then refiled.
I see.
As the hearing officer considered them together, I think it makes sense for us to do the same.
I agree.
So objectors Valerie Adams and Devin Jones filed objections to the nomination papers of Ruth Pellegrini. The first, filed as 502, incorrectly spelled the candidate's name. The second was exactly the same, except it was filed with the correct spelling. The objector's objection is based on an allegedly deficient statement of candidacy, the filing of insufficient signatures, and circulator deficiencies. Objectors filed a motion for summary judgment. A staff count of the number of signatures filed revealed the candidate submitted 932 signatures, which is 396 below the minimum required. The candidate attempted to rehabilitate her failure to file the minimum number of signatures by arguing that she relied on information from the State Board of Elections staff, which led her to misunderstand the filing requirement as only 132 signatures. I recommend that the objector's motion for summary judgment be granted solely on the basis that the candidate failed to meet the minimum number of signatures required and that the candidate's name not be certified to the ballot for the office of U.S. Representative for the 1st Congressional District of Illinois. I will also add that in this particular case, individuals other than the parties and their attorneys have tried to chime in and participate in this proceeding, which is in violation of our rules of procedure. So I ask that only the candidates and their lawyers be permitted to speak right now.
Thank you, Ms. Malowitz. All right, does the attorney for the objector wish to be heard? Is there someone here on behalf of Adams and Jones? If not, is there someone here on behalf of the candidate? All right.
I am the candidate.
Yes.
I am the candidate.
Okay.
And I would like
to speak.
All right. Good morning. My name is Ruth Pellegrini. I'm the independent candidate running in the 1st Congressional District, and I'm respectfully requesting that you decline the recommendation of the hearing officer, Mr. Krasny, and allow my name to remain on the November ballot for the following reasons. First, I disagree with the hearing officer's statement that the facts in this case are, quote, undisputed, unquote, and that I failed to submit the requisite number of signatures to appear on the ballot for the U.S. Representative for 1st Congressional District, page 5 of the report. Second, the report failed to include my testimony that, quote, nowhere in the guide did it state or advise a U.S. representative that the figure listed had taken into account Judge Pallmeyer's order, that I had never been advised of this.
I'm sorry, we're not hearing you right now.
Oh, Ms. Pellegrini, it looks like you may have muted your microphone. If you could try unmuting it.
Oh my God, we'll just go out completely.
There should be a universal signal to tell people to unmute.
I'll
Some kind
mention
of
any
sign
topic.
language.
Oh, I'm so sorry.
Yeah, we didn't, you better start over. We did not hear you.
Oh, I'm so sorry. Something came through my phone and knocked me off.
Oh,
Just a
okay.
minute,
Well,
please.
go right ahead. Did you have enough signatures? Is that,
Yeah, hold
what's
on
the
just a
basis?
minute. Oh,
What in the world is happening here?
all right. Can you hear me? Is
Yes.
this better?
This
I'm
would be your
sorry.
chance to tell us why
Okay.
we should not adopt the recommendation of the general counsel. So go right ahead, please.
Yes, yes. Did you hear any of what I said? That
Well, if you could go over it. I don't know. We didn't hear very much. And,
Oh, okay.
we have a
Okay.
long agenda today.
All right. First, I disagree with the hearing officer's statement that the facts of this case are undisputed and that I failed to submit the requisite number of signatures to appear on the ballot. Did you hear that part? And second, the report failed to include my testimony that nowhere in the guide did it state or advise that a U.S. representative that I confirmed that I need only 10% of the 1,328, which is approximately 132 signatures. And this was confirmed when I spoke to Mr. Brent Davis at the Division of Election Operations Director on May 13th. So the undisputed facts are, one, that the Illinois Board of Elections issued and presented to candidates its May 28th, 2020 amended candidates guide. And two, in the amended guide, it specifically advised and instructed candidates that the minimum and maximum number of signatures to get on the ballot was subject to the order entered by Chief Judge Rebecca Paulmeyer in the case of Libertarian Party of Illinois versus J.B. Pritzker. And three, in multiple pages, numbers 3, 4, 8, 22, 23, 25, 29, 35, 37, 39, 47, 51 to 53, 55, 57, 59 to 61, the board stated, please reference addendum B for changes to the filing period or new party and independent candidates applicable to the 2020 filing period only. Specific for U.S. Representative, the guide stated on page 23, please review addendums A and B for updated requirements for new party and independent candidates. Number 4, according to Judge Paulmeyer's order, an independent or new party candidate was only required to submit 10% of the minimum number of signatures listed in the guide. However, the candidate's guidebook failed to mention that 10% had already been deducted. Yet, yes, the cross out of the old numbers are in the book, but the constant updates and changes that were made to the guidebook because we're in the middle of a pandemic, a reasonable person cannot assume the deductions were already made. 6, nowhere in the guide did it state that the election board or the figure listed had been taken into account or applied Judge Paulmeyer's order. Also, there wasn't an updated version of the guidebook published without previous information about it being crossed out. This creates confusion, and there was confusion for the candidates and the objectors. Number 7, taking into account Judge Paulmeyer's order, reducing the number of signatures to 10%, and the number listed by the election board in the guide, that is 1,328. The reasonable belief by anyone reading the guide would have been that the candidate running for U.S. Rep of the 1st District congressional district would need 132 signatures. I turned in 932 signatures. Now, why would I turn in 932 if I truly understood that the required minimum was 1,328? 932 is close to 1,328. Why wouldn't I just keep collecting signatures? And because I'm running for Congress, it behooves me to fulfill the requirements to make the ballot. In addition, the independent and new party candidates are given a range of 1,328 to 2,124. This leads to confusion as well. How do you determine the number within the range? Our category should have been a set number like the Republicans and Democrats. According to the Illinois Election Code law, I would need 5 to 8% of the signatures of the registered voters who voted in the last general election for the 1st congressional district. According to the published reports, approximately 159,000 people voted in the last election. So 5 to 8%, which is approximately 7,000 to 13,000 signatures in a world pre-coronavirus. Again, the election code law gives a range and not a set number, which is confusion in itself. The original numbers listed in the guidebook before the crossouts are 13,246 to 21,240. This is more than 5 to 8% of the voters that voted in the last election for 1st District. Those numbers were reduced to 1,328 to 2,124. However, the guidebook never indicated this. It was the final revision. Because of the pandemic, things are changing. There's no version of the guidebook that was published that states a final version. Number 8, as a confirmation of the minimum signatures needed to remain on the ballot, I personally contacted and spoke with Mr. Brent Davis, Director of the Division of Election Operations of the Illinois Board of Elections. Number 9, Mr. Davis calculated the number of signatures required for me to remain on the ballot while I was on the phone with him. He confirmed that I needed 132. In addition, going back to the conversation with Mr. Brent Davis, confirming that all I needed was 132 signatures, he had not told me that it made it clear that I needed 1,328, then I would have continued collecting more signatures because I was already close enough to the 1,328, having 932. 10, in support of my conversation with Mr. Brent Davis, I submitted my certified statements and testified at the hearing. Neither my statement nor testimony has been refuted. Number 11, I relied on the election board guide and the advice of Mr. Davis that I only needed 132 signatures. 12, if I had been told that I need 1,328 signatures, I would have obtained and submitted more than that figure. 13, there's been no evidence presented by the objectors nor the hearing officer's report refuting the fact that based on the guide and Mr. Davis, the minimum number required for an independent candidate for U.S. Rep in the 1st Congressional District was 132 signatures. 14, according to the hearing officer, even if he were to sustain all objections other than not having the minimum number of signatures, I submitted 181 signatures, page 10. So remaining objections, adopting and reasserting the position set forth in your response to the objections motion for summary judgment filed by Adams and Jones. There's no question that in the last few months, we're in an unprecedented time in this country and in the world. And the candidates attempting to understand and adhere to the election statutes, codes, and judicial rulings is received from the Board of Elections. At best, one could describe it as absolute chaos. There was an order from the governor that people were to stay in their homes. The time to submit signatures was extended, then reduced. Alleged signatures could be obtained electronically, but the election code made no provision for this situation, and no instructions were provided by the board as to what would be acceptable. The hearing officer's report states that estoppel is applied against state only to prevent fraud and injustice on page 7. What is more unjust than kicking someone off the ballot who relied on Judge Palmer's order, reducing the number of signatures required to 132, confirming that figure with the director, Mr. Davis, at the Board of Elections in the midst of a pandemic when everyone is ordered to stay at home. In addition, several election specialists encouraged me to disobey a stay-at-home order and specifically told me that I can still go out and collect what's known as wet signatures. We were only to go out for essentials and collecting signatures for an election, which is not essential. The hearing officer's reliance on the ruling invested versus DuPage County Elections Commission, 335 Illinois Appellate 3rd, 156, 779 Northeast, 2376, 2002 Illinois Appellate, Lexus 1064, 268 Illinois December 762, and Jackson Hicks versus East St. Louis Board of Elections, 2015 Illinois 11892828 NE 3D 170 is misplaced. In Vestrup, unlike the present case, the candidate did not submit the requisite number of signatures. In Jackson Hicks, the Supreme Court explicitly stated that some substantial compliance is not a valid justification for deviating from the clear and unambiguous and minimum signature threshold set by the legislature. First, if this were the case, then Chief Judge Palmer's order should not have been applied, but clearly the Board of Elections adopted and applied her order by adding parts of her order to the candidate guidebook, i.e. addendum A and B. Second, the threshold minimum number of signatures required was now altered and amended, and anything but clear and unambiguous, quote unquote. Further, the accuracy means of communicating the minimum number of signatures in Jackson Hicks was not at issue, as in the present case, and there was no pandemic affecting a candidate's ability to obtain signatures. The candidate in Jackson Hicks did not assert estoppel based on at best.
Ms. Pellegrini, you don't have to read these opinions to us. Just summarize,
yes.
Please.
Okay. Yes, I'm almost done. Clearly, the Supreme Court in Jackson Hicks did not, with good reason, consider how a pandemic might affect a candidate's ability to secure signatures. Whether communication with the Board of Elections could be affected And if a federal court would alter the minimum number of signatures required, in the opinion, it speaks of ensuring consistency in questions whether 90% or 70% would constitute quote unquote substantial compliance. Isn't that what Justice Pallmeyer actually did? The hearing officer's report states that there must be compelling circumstances to justify an application of estoppel. What is more compelling than a pandemic? As for consulting with counsel, the last pandemic in the U.S. was 1918, Spanish flu. Thus, it is doubtful that any attorney could have advised me as to the number of signatures I needed to stay on the ballot, or that applying to Pallmeyer's order of need of only 10% to the 1328 figure presented by the Board of Elections was incorrect. So in the case of Atkinson and Schelling, in that case, they held the court candidate's name should be printed on the ballot, even though the candidate filed less than the minimum number of required signatures, because the election authority had published an erroneous statement of required number of signatures, which was misinformation. In my case, I was verbally told something over the phone, which means it was left up to me as the burden of proof to have Mr. Davis and other election specialists come in and testify, which gives them the opportunity to defend themselves by either corroborating or refuting what they told me over the phone. Unfortunately, we never had the opportunity to find out because my request to subpoena Mr. Davis and several other election specialists was denied. Even if these individuals were willing to volunteer to testify without a subpoena, I was referred to General Counsel of the Illinois State Board of Elections. How can I prove my case if I am impeded by the board to interview their employees? This is catch-22. Lastly, based on the hearing officer's calculation, I submitted more than a requisite minimum number of signatures required, 132, and I ask that you allow my name to remain on the ballot. Thank you for your time, attention,
Thank you.
and consideration.
Thank Ms. Malwitz, would you like to respond to that?
Certainly. It sounds like the candidate has misunderstood both the libertarian order as well as the law applicable to her candidacy. The State Board of Elections cannot give legal advice. Its candidate guides are merely materials to help people understand some of the basic requirements. However, the candidate's guide did attach the actual libertarian orders to the candidate's guide, so that way candidates would have the opportunity to review them and to take them to their counsel if that is what they chose to do. A mistake of fact or a mistake of law, a misunderstanding is not something that can allow the board to deviate from the requirements of Article 10 of the Election Code as modified by the preliminary injunction order. And the candidate's misunderstanding of those requirements is not relevant to this proceeding. She did not submit the requisite number of signatures and she cannot be on the ballot.
Thank you, Ms. Malwitz. There's no one here on behalf of Adams and Jones. So we'll hear from members of the board.
Mr. Chairman.
Yes, Member Hain.
I just want to comment that in the midst of this plague sweeping the country, there was a candidate for president of the United States in Wisconsin, was denied a place on the ballot because his people were 2 minutes late in filing. The law is the law. We are a strict construction type body. We are a ministerial regulatory body, and we cannot change the law. The law has been modified in some respects by a United States Circuit Judge, but other than that, we follow the law, and she didn't make it. She didn't make the right number of signatures, and that's it. Close is not good enough with the election code. Maybe in horseshoes, but not the election code.
Thank you, Member Hain. Other members of the board have comments or questions? If not, I'd entertain a motion regarding the recommendation of the General Counsel.
Mr. Chairman, I'll make a motion that we grant the objector's motion for summary judgment and adopt the findings or the recommendation of our General Counsel that the candidate not be certified for the ballot for the fall election.
All right, motion by Member Cadigan. Is there a second?
Second.
Anybody else wish to be heard? If not, roll call, please.
Mr. Cadigan?
Yes.
Ms. Donahue?
Yes.
Mr. Hain?
Yes.
Mr. McGuffich?
Yes.
Ms. O'Brien?
Yes.
Ms. Watson?
Yes.
Vice Chairman Lineberry? Oh, you're
Yeah,
muted.
sorry.
It's okay. Chairman Scholes.
Yes. All right, objection sustained.
Next,
Thank you, Ms. Pellegrini. Bixler versus, and Perkins versus Redpath.
20 SOEB GE 504. The objectors are represented by Jeffrey Meyer and the candidate is pro se. Objectors Francis Bixler and Mary Perkins filed an objection to the nomination papers of Bill Redpath on the basis that the candidate's nomination petitions would be untimely and in violation of circulator requirements in the Libertarian Party if the Libertarian Party preliminary injunction order were vacated, and that the candidate has failed to meet the minimum signature requirements under the preliminary injunction order, as those signatures contain material deficiencies evidencing a pattern of alleged fraud. Also, that the candidate's statement of candidacy was insufficient. The hearing officer found, and I concur, that the candidate and his nomination papers are subject to the modified deadline, circulator, and signature requirements articulated in the Libertarian Party preliminary injunction order. A record examination was conducted and resulted in the candidate having 772 signatures above the statutory minimum as modified by the preliminary injunction order. A Rule 9 hearing resulted in the overturning of 162 rulings by SBE staff, resulting in a final signature count of 2,209 valid signatures, which is 610 over the modified thresholds. Now, as the Seventh Circuit affirmed the Libertarian Party preliminary injunction order yesterday, I recommend that the objections pertaining to timeliness of the petition and the circulator requirement be dismissed as moot. However, as the candidate has filed sufficient signatures even after the outcome of the Rule 9 motion, and no pattern of fraud or deficiency in the statement of candidacy has been demonstrated, the hearing officer recommends, and I concur, that the objection be overruled and candidate's name be certified to the ballot as an independent candidate for nomination to the office of U.S. Representative for the 6th Congressional District of Illinois. I would note for the board, this is a partial adoption of the hearing officer's opinion because of the intervening decision yesterday from the appellate court that mooted some but not all of the objections.
Thank you, Ms. Melowitz. So is there someone here on behalf of the objector?
I am, Mr.
Attorney
Chairman,
Meyer?
Jeffrey Meyer on behalf of the objectors.
Yes, this would be your opportunity to be heard, sir.
Thank you, Mr. Chairman. First, I did file a written exception to the hearing officer's recommendation. I want to make sure that that has been received and is a part of the record.
Yes, sir.
Okay, thank you, Mr. Chairman. Briefly, first, this is the first I'm learning of the Seventh Circuit's opinion issued yesterday, and so I haven't had the advantage of reading it. I would note that one of the things that I reference in our exception is that this is a case that my clients were not a party to. Even if this is an agreement between the State Board of Elections and certain litigants, we weren't a party and the State Board of Elections is not our privy. Typically, an agreed order in any litigation matter would have no preclusive effect on anyone except the parties to the case or their privies. So we would take exception with a finding that an agreed order in litigation has an effect at all on anyone else. I would also note that I agreed with the board's argument in that case that while a federal court can certainly find a statute or a requirement on ballot access to be constitutional or not, or constitutional is applied or not, that a federal court has no authority whatsoever to rewrite an election code. The Sixth Circuit in the Isaki case, I might be mispronouncing that, but the Sixth Circuit found that very thing and said that courts can strike them or not, but then it's up to the state to write its own remedy that would be more narrowly tailored to not be violative of constitutional principles. That certainly did not happen here. As one of the members has mentioned a number of times today, you are a ministerial body. You're a regulatory body. You are not a body that has any statutory authority or, pardon me, constitutional authority to rewrite statutes. The only entity that could rewrite the election code in Illinois is the legislature and a bill that's signed by the governor. That did not happen here. So even if this was an agreed order, I don't think it's an agreed order that has a preclusive effect, and I don't think it's applicable. Again, I haven't had the advantage of reading the Seventh Circuit case, but I state that for the record. Setting that aside for a moment, one thing that's very concerning to me is that we had a line-by-line signature objection, and there are somewhere in excess of 700 signatures that we objected to on a basis that, frankly, there has been no formal ruling on. We objected to the signatures of over 700 voters on that nominating petition who voted or cast ballots in the partisan primary in March of 2020. The hearing officer makes no finding in his recommendation, nor did I hear one from general counsel in terms of recommendation in her comments, one way or another on those objections. I think that since it was an objection that was raised, it's one that could affect the outcome if they are stricken. I think that's one that the board has to make a finding on. The hearing officer made no such finding, and he gave us no hearing on that issue. We were never afforded any opportunity to put evidence on as to that, as to those specific objections brought on the basis of signers being partisan primary voters in March of 2020. Part of my exception contains what I'm submitting as an offer of proof for purposes of the record as to the voting history of those approximately 700 voters. We have certified voting records from DuPage, Kane, Lake, and McHenry County. Unfortunately, we were not able to get certified voting records from Cook County because the Cook County Clerk's Office would not produce them to me without a subpoena. This board denied my request for a subpoena for those records. So as part of the offer of proof, we also submit an affidavit in essence that would establish these as a business record. On the issue of partisan primary voters and the eligibility to sign nominating petitions, very briefly, it would make no sense to interpret the election code as precluding Republicans from interfering in the Democrats' primary or vice versa, but then to say it's perfectly acceptable for people who have picked a lane in an election cycle to then pick a candidate of another party to play spoiler in a congressional race. But that's in essence what not striking these signatures would do. There's no question that a Republican can't sign a Democrat's petition or vice versa. And there should be no question that a Republican or a Democrat who has picked that lane in this election cycle should be able to sign the nominating petition of a third party either. To rule otherwise would be completely inconsistent with a well-established body of law in this state that once you pick a lane in an election cycle, that's the lane you have to stay in for the election cycle. You can change from cycle to cycle. And this is, I think, something that the general counsel addressed in their concurrence on the recommendation to deny the subpoena request. We're not arguing that you can't change from cycle to cycle. We're simply saying in this election cycle, if you're a Republican, you're a Republican. If you're a Democrat, you're a Democrat. You can't be a Republican and a Libertarian. Those 700 or approximately 700 signatures should be stricken as well, which would put the candidate below the minimum number of required signatures, even if the injunctive order has preclusive effect and applies here. For those reasons, we would ask that the objection be sustained and the candidate's name be stricken. Thank you.
Thank you, Mr. Meyer. Questions for Attorney Meyer? Candidate Redpath,
Yes,
would you like to be heard at this time, sir?
yes, I would. First of all, I would like to comment on this pick a lane theory. I find that to be total funk, to be perfectly forthright. Somebody might have voted in a party primary, but they may not have liked the winner of their party's primary. You can't enforce somebody who voted in a Democratic primary or Republican primary to vote that way in the general election. You can't do that. They may not like the results. They may want to see other candidates on there. A petition circulation is not a primary. Not a primary. It was a petition circulation, and I gathered almost half of those signatures myself. There was no fraud involved. This is not prohibited by statute. It is not prohibited by statute in Illinois that somebody who votes in a partisan primary cannot sign an independent or new party petition. This legal theory has never been raised before. I've been told by people who've been involved in the Libertarian Party of Illinois far longer and more deeply than I have, that this legal theory has never been advanced before in objections to Libertarian Party petitions. It was raised informally, I've been told, about 10 years ago, when an officer of the Republican Party of Illinois signed a Libertarian Party petition. And the Republicans saw this, and they said, hey, that's our guy. You can't have him. Well, it was ruled a valid signature, even though this person was the Republican Party. He signed the Libertarian Party petition. It was found to be a valid signature. People are free to vote however they want in a general election, no matter what they did in primary, and they are free in Illinois to sign an independent or third-party petition, whether they voted in the primary or not. And that's the law as I understand it.
Thank you, Mr. Redpath. Ms. Malowitz, would you like to respond to any of that?
Very briefly, I just want to clarify the board that the signatures that Mr. Meyer is referring to as having been unruled upon, I disagree that those have been unruled upon. His objection, which is based on the fact that the signers had voted in the primary and then signed later on this petition, has no basis in law. That is my finding, and that is what I encourage the board to accept. We cannot create statutes that don't exist. There is no statute that says that someone cannot sign a petition for an independent candidate or a new party candidate after having voted in the primary. There used to be such a statute. In 1971, that statute was ruled unconstitutional, and then it was later repealed by the General Assembly. So it simply isn't there, and I would encourage the board to follow the law as written, which does not allow such an objection.
Thank you, Ms. Malowitz. Questions from members of the board of either the candidate or the objector or our general counsel, or comments?
Mr. Meyer, what's your response to Ms. Malowitz's statement that that statute that was once in place is no longer in place, and that a signer of a petition in a primary is not precluded from signing candidate of an independent or third party for the general?
Thank you, Mr. Cadigan. The 1971 case that council is referring to struck a provision in the election code that locked people in for a specific period of 2 years to a party identification. And the Supreme Court found that the U.S. Supreme Court found that unconstitutional because it would have precluded somebody from being a Republican in this primary, but then you get a municipal primary that happens within a period of less than 2 years, and then you wouldn't be able to pick a lane during that new election cycle. That's all the U.S. Supreme Court struck. They said that you can't lock people in for 2 years because they have a constitutional right to reassociate in a new election cycle. That decision actually references a New York statute that is basically the law now in Illinois, that you pick a lane in each election cycle. That's what it struck. It didn't strike all provisions of the election code. You still have section 710 and section 88 of the election code that say you can't sign a nominating petition for more than one party. And that's applicable to Article 10 under Section 10.4, which says that the rest of the election code applies to Article 10. So you still have 2 places in the election code that say you can't sign nominating petitions for more than one party. The appellate courts in Illinois, long since that 1971 decision, have said that means within a specific election cycle. So contrary to council's opinion, there are express prohibitions in the election code as it exists today that are applicable to Article 10 by reference under section or language in 10.4 that I've highlighted in our exceptions brief.
And it's true, there is a prohibition for candidates. If they voted in a party primary, they cannot then run for office as a candidate.
Right.
But that is not something that applies to signers of a petition. And while I agree that the unconstitutionality ruling was on something broader, it's really the General Assembly's later action of repealing the statute entirely rather than shortening the duration of the statute that speaks volumes here. There simply is not a statute that supports Mr. Martin's interpretation.
Thank you, Ms. Malowitz. Other members of the board have questions or comments? All right, if not, I'll entertain a motion on the recommendation of our general counsel. If not, go ahead, Member Hain.
Well, I think we're all stuck on this. Counselor Meyer had a pretty concise and eloquent position. So I don't know. I respect very much Marnie's opinions, but I honestly don't know here. Marnie, can you give us some more flesh, so to speak, on the bones of these arguments?
Certainly, certainly. I think an important thing for the board to recognize is that this candidate is not just a couple of signatures over. This candidate is at least 610 signatures over the limit here, if not 772. So that certainly is something to keep in mind. This is not a close case in any means. And the only contingency that Mr. Meyer is speaking about is based on a statute that was repealed by the General Assembly. There's simply no way to overcome the fact that this candidate is hundreds and hundreds of signatures over the requirement.
And this relates somewhat to the Justice Paul Meyer's decision too?
Yes, there were multiple objections that were made here by the objectors, and two of those objections were based essentially on what would happen if the Libertarian Party PIO was vacated. So those two were that the nominating petition would have been untimely because it was filed on July 20th and not the original date in June, and that the circulator requirements would, if the PIO had been overturned, have been back in effect. So therefore, I'm recommending here that those two particular objections as to the timeliness as well as the circulator requirements be dismissed as moot, because in light of the Libertarian opinion, those are essentially gone. You as a board are absolutely bound to follow the Libertarian Party preliminary injunction here, and therefore those two aspects of this objection are gone. So the other things that remain are, number one, an allegation of a pattern of fraud, which there's absolutely no support for here. There's a bald allegation that the candidate's statement of candidacy was insufficient, but there's no documentation of that. That has not been proven or shown in any way. And then finally, there is this objection as to the signature requirement. But again, the only, as this candidate is hundreds and hundreds of signatures over the requirement, and Mr. Meyer's only argument in response to that is by invoking a 1971 statute that was repealed, basically shows this candidate is very, you know, he is in a good spot to get on the ballot based on this. He has met the requirements of the statute, and I don't think that the board can ignore the requirements of the statute here.
I make a motion that we adopt the position of our general counsel. I respect the arguments of Mr. Meyer. I stated this before. I think we have a gun to our, not in his words, but we have a judicial gun to our head by a judge who has seen fit to rewrite the statute in some respects, but those are the facts. As Mr. Dooley once said, it's good to know the law, but it's better to know the judge. And I don't know this judge. So I'd make that a motion. We adopt the position of counsel.
All right.
Mr. Chairman, I'll
yes.
second Member Haynes' motion with this comment. I agree with him. This is a difficult one, and you know, ergo the hesitation of all the members to make the motion. I think Marnie, our general counsel, makes a good point about the statute, and we are obligated to follow the letter of the law, and there is no express prohibition against the conduct that Attorney Meyer raises in his exception to the ruling. But I'm also very sympathetic to the arguments Attorney Meyer makes, and I think this is something that the courts are going to have to sort out, because he does point out that there is a valid prohibition against petition signers signing nominating petitions for two different party candidates in the same election cycle. So it's a compelling argument that he makes, but at the end of the day, I do think that we're obligated to follow the statute. And so I second Member Haynes' motion.
Thank you, Vice Chairman Lenneberry. So a motion by Member Haynes, second by Vice Chairman Lenneberry. Any other comments or questions? If not, we'll have a roll call, please.
Mr. Cadigan?
I've listened to the arguments of counsel and Member Linneberry and Member Hain, but I think this is kind of a close one. I am going to vote no on the motion, and hope that we do get some guidance from the General Assembly and the courts on what's a issue that needs some clarity.
All right.
Ms. Donahue?
Yes.
Mr. Hain?
Yes.
Mr. McGuffich?
Yes.
Ms. O'Brien?
Yes.
Ms. Watson?
Yes.
Vice Chairman Linneberry?
Yes.
Chairman Schultz?
Yes. All right, so the objection will be overruled. Candidate will be on the ballot. Thank you, Mr. Meyer. Thank you, Mr. Redpath.
Thank you, Mr. Chairman.
Thank you.
You're welcome. Flores versus Cleveland.
20 SOEB GE 505. The objector is represented by Kevin Morphew, and the candidate is represented by Pericles Abbasi. This is another case involving the Libertarian Party PIO. Objector Kevin Flores filed an objection to the nomination papers of Clayton Cleveland on the basis that if the Seventh Circuit overruled the Libertarian Party PIO, which reduced signature requirements for this election, then the candidate failed to meet the statutory minimum signatures articulated in Article 10 and should not be certified to the ballot. The candidate filed a motion to strike and dismiss. Based on the August 20th decision from the Seventh Circuit upholding the Libertarian Party preliminary injunction order, I recommend that the objection be dismissed as moot, the candidate's motion to strike and dismiss be dismissed as moot, and the candidate be certified to the ballot for representative to the General Assembly for the 80th Representative District in Illinois. This one probably could have been handled with the early ones, but didn't want to take it out of turn.
Yeah, well, that's fine. Thank you. Mr. Morphew?
Yes, I would reincorporate my statements from the previous cases and
Thank you.
stand on the recommendation.
And Mr. Abbasi?
I would just ask the board to accept the recommendation of the general counsel.
Thank you, sir. All right, is there a motion then on that recommendation?
I'll make a motion. We adopt the recommendation of our general counsel and not certify the candidate for the fall election.
All right, motion member Cadigan, is there a second?
Second.
I think that was,
Can I get the motion clearly again, please?
The motion.
I think you might have Member Cadigan, I think you accidentally said to not certify.
Oh, I'm sorry, to certify.
Thank you.
all right.
So we need the motion restated?
I make a motion. We adopt the recommendation of our general counsel and certify the candidate for the fall 2020 ballot.
All right, is there a second? Second, member Watson, roll call, please.
Mr. Cadigan?
Yes.
Ms. Donahue?
Yes.
Mr. Hain?
Yes.
Mr. McGuffich?
Yes.
Ms. O'Brien?
Yes.
Ms. Watson?
Yes.
Vice Chairman Linneberry?
Yes.
Chairman Schultz?
Yes. All right, that objection will be overruled and he'll be on the ballot. Agenda item, what are we down to, Marnie? S?
S. Kies versus Sarfraz, 20 SOEB GE 506. The objector is represented by Kevin Morphew and the candidate is represented by Vito Mastrangelo. Before I explain this case, I want to flag for everyone that this is a very, very close case. We are down to two signatures rather here. So you'll note that I do divert a bit from the hearing officer's findings, and I ask that the board pay close attention to that. Here, objector Christopher Kies filed an objection to the nominating papers of Alia Sarfraz, alleging, among other things, that she filed an insufficient number of signatures after striking signatures that of individuals who were not registered at the address shown. whose signatures were not genuine, who reside outside the district, whose addresses are missing or incomplete, and who signed the petition more than once. The candidate filed a motion for summary judgment and a motion for sample records exam and for rule to show cause. A records examination was conducted by the State Board of Elections, which resulted in the candidate having 4 signatures fewer than required. A Rule 9.
How many fewer?
4 signatures fewer than required. A Rule 9 evidentiary hearing was held on August 14, 2020, during which the candidate submitted affidavits to rehabilitate 5 signatures that were struck during the records exam. As a result of the Rule 9 hearing, the hearing officer found that the candidate was able to rehabilitate 2 signatures with competent affidavits, but unable to rehabilitate any others. The result of the Rule 9 hearing was that the candidate had filed 235 valid signatures, which was 2 under the minimum required. I do not concur in the findings of the hearing officer as to 2 of the affidavits submitted, the Masterson affidavit and the Patel affidavit. And I find that the candidate submitted evidence sufficient to rehabilitate 4 signatures, resulting in the candidate having 237 valid signatures, the exact minimum number required. As such, I recommend the objection be overruled, that the candidate's motions be denied as moot, and that the name of the candidate be certified to the ballot for the office of representative to the General Assembly for the 52nd Representative District.
Thank you, Ms. Malwitz. Attorney Morphew, you're here for the objector?
I am. So at issue are really 3 affidavits here. The candidate submitted 5 affidavits to rehabilitate the objection, voter not registered at address shown. No certified records from an electoral authority were submitted as evidence to rehabilitate these signatures. One of the affidavits at issue, and this is Diana Peterson Farraco, she signed on the petition sheet 51, page 51, line 5. The board at the records exam found that there was no voter by that name registered at that address. The individual submitted an affidavit stating that she, in fact, is registered at that address. That affidavit lacks foundation. She has no factual basis to assert whether she is or is not registered to vote. Rather, the board or the electoral authority is in the position to make that call. The candidate could have provided a certified record. They chose not to. They chose through the affidavit. And so I believe this affidavit, which was admitted and was counted towards the candidate's total, lacks foundation. This individual doesn't know whether or not they're registered to vote. If the board were to allow every individual to just rehabilitate it by affidavit, we wouldn't have to have certified records be required under the rules. So,
well, Mr. Murphy, do they have to be registered to vote or eligible to vote?
They have to be registered to vote at the address shown.
All right.
And
go ahead.
The board found at the records examiner that that individual is not registered to vote at the address shown. The only evidence.
I object to Attorney Morphew raising issues that he not bring up in an exception to the hearing officer's recommendation.
Well, you'll have a chance to be heard, sir. Sir, you'll have a chance to be heard. Go ahead, Mr. Morphew.
Okay.
Certainly. So we take exception to the admission of that affidavit. It lacks foundation. There is no supporting evidence of the board's records to support this. It's just the individual saying, "I'm registered to vote. Take my word for it." Of course, everyone thinks they're registered to vote. There were nearly 400 signatures submitted by the candidate, and they all thought they were registered to vote at the address shown. They weren't. A significant number were not registered to vote at the address shown. So the candidate's evidence was insufficient to rebut the board's finding on that particular affidavit, the Diana Peterson Farraco affidavit. And then turning to the other 2 affidavits that the general counsel has found that has disagreed with the hearing officer's report, the individual, Vipul Patel, wrote on the petition sheet that his address is 519 Shutkowski Drive in Hoffman Estates, Illinois. And that's on page 68, line 7 of her petition. That they're not registered at that address. Section 3-1.2 of the election code is clear. It states the voter must be registered to vote at the address shown opposite his signature on the petition. He's not registered at that address. He's registered at 5190. His affidavit just simply states, I'm registered at 5190. It supports the fact that he's not registered to vote at the address shown on the petition sheet. And further, the Appendix B is very clear that under the objection, signer not registered at the address shown, if the address on the voter's registration does not match the address opposite their name on the petition, the objection shall be sustained. And so for those reasons, and the other affidavit, the individual has a 2 Revere Drive on the petition sheet. She writes 52 Revere Drive on her affidavit. So the objection was that the signer's not registered at the address shown, and they're not. And the affidavits don't do anything to rehabilitate that.
All right, thank you, Mr. Morphew. We'll hear from the candidate or representative.
Thank you, Chairman. Well, first, I must object to Attorney Morphew raising an issue that the hearing officer, in the hearing officer's recommendations, that he made a finding on. He did not file exceptions. I thought that was required.
It's not. They didn't do it orally.
Go ahead, sir.
The candidate had her exceptions, and the candidate appreciates the general counsel's recognizing that the signature lines were in substantial compliance with the requirements of the law. I will address the one issue that Attorney Morphew raised that he has not raised until now about the exception to the hearing officer's finding on the Farraco affidavit. He claims that there was no foundation, but the board's rules specifically allow affidavits to rehabilitate signature lines. He says there's no certified records, but certified records are not the only way to rehabilitate a signature line. The affidavit clearly shows that she lives at the address she wrote. And also I'll raise something briefly now that I will come back to in just a minute, and that is that we have provided the board with, we point the board to its own records where that were given to us, copies of which were given to us, that shows that Ms. Farraco does live at that address. With respect to, so we asked that the hearing officer's recommendation and the general counsel's recommendation to accept that part of the hearing officer's finding be adopted. And that gets us back to the too short, and the hearing officer recognizes that the 2 additional lines that the affidavits that the hearing officer did not think were sufficient are actually, and again, I suggest they are in substantial compliance with what's required for a signature line. I have attached those to our exceptions, the sheets, so that you can see exactly what the line shows. With respect to, let's see, I'll do Ms. Masterson first, Nina Masterson. She signs at an address on Revere Drive. Admittedly, the first digit is a little difficult to parse out, but it can only be 2 numbers, either an 8 or a 2. And look at that and say an 8 and it's not a 2. If you look at it closely, you can see that when she finished an 8 or a 5, you can see that when she finishes the 5, she continues the bottom all the way up to start the 2. So it's pretty clear that it's, it's a little sloppy, but it's pretty clear it's a 52 Revere Drive. So I appreciate the general counsel, recommending that affidavit be allowed to rehabilitate the signature line. Finally, the Patel affidavit. This one, again, involves the address, as all of these do. The address is that he wrote on the petition is admittedly 519, not 5190. And, this, I call it a Scrivener's error when I comment on this in our pleadings. And again, based on what, now in this case, the objection detail report, the staff actually found the name of this voter as a registered voter at 5190 Chatosky Drive. That is what the affidavit says. The registered voter says that he's registered vote at 5190 Chatosky Drive, and he says he signed a petition sheet on that page and line. So we have a number of circumstances that corroborate that this was simply, I assume, a hurriedly attempt, to write his address. And one final note on that, you can look at the other addresses on the sheet and you can see that these are all in the same neighborhood on the same block, and 519, looks out of place. And it's relatively clear that this was simply a mistake where he went on to his street name before he finished writing the street number. Those two affidavits, in addition to the ones that the hearing officer adopted as rehabilitating the lines, those two would put the candidate at the required minimum number of signatures. So that should be sufficient to keep the candidate on the ballot, and I would ask the board to do that. But I do want to bring up this point again that I raised, from our submission of evidence to the hearing officer to now, and that is that the data that was given to us by the state board in our statewide voter rolls that the Illinois Green Party purchased from the state board, we tried to go through that to rehabilitate signatures in advance of the proceedings before the board, and we found exact matches with signatures, and we tried to relate those to the board and the hearings officer before the records exam, but unfortunately I filed it the night before, and the hearing officer did not have an opportunity to look at that before the exam. But we tried to focus the exam on those signature lines that we thought were direct matches. Now, I do not know what happened at the record exam. I don't know what records they looked at. I don't know who did it. And so I don't know what happened, but all I know is the board's own records provided to us show matches, not just for Patel and Masterson and Farraco, but several other signers that had, the lines were rejected. And I have no explanation for that. And so we have asked the board to take judicial notice, to take notice of their own, this is the statewide, I assume that when we purchased the statewide voter registration list, I assume that comes from the centralized voter list that the state board creates and manages according to statute. So we were asking the board to take a look at that list, and we believe it will show that these voters, these signers represented in the affidavits and others that are in the table that we attached as an appendix, that there are matches that should also be rehabilitated signature lines. But that's not necessary to do that if the board adopts the general counsel's recommendations with these two additional affidavits and adopts a recommendation that the candidate be certified for the ballot. That's all I have, unless there are questions from board members.
Thank you. Questions from members of the board, or comments or questions for our general counsel?
I have a question.
Go ahead, Member Watson.
If I am hearing all of the arguments correctly, there are two signers that were found to be not registered at the address shown. Is that correct?
That was the finding of the hearing officer based upon the fact that one digit of that of each of those two individuals' address was either missing or difficult to read. So the street name was correct and the street address was correct, but for a digit.
Okay, so I think the law is pretty clear, and the pattern and practice of the board is clear. The case law is clear. If you are not registered at the address shown, then the objection is sustained. If we find that that is an absolute, which I purport that it is, then this candidate would be off the ballot. Is that correct, Bernie?
I agree that if you don't count this as a scrivener's error, and if the one digit.
I am unaware of any case law which allows a scrivener's error on an address shown. Objection. Do you have case law for that?
I don't with me at the moment. That's a good point.
Mr. Chairman?
Yes.
I don't think that we need to get to the validity or invalidity of the rehabilitation, because two of the signers were found not to be registered at the address shown.
Well, I think, Mr. Chairman.
Yes, Member Cadigan, go ahead.
Well, it may escape all of us right now if there's case law on a scrivener's error or a hastily written down address on a petition, which is often a transaction that takes place in the course of 30 seconds or less. There's certainly the broader principle of ballot access that we operate under. So
There is, I agree, Member Cadigan, that there is a broad principle of ballot access, but there's an absolute objection to not registered at address shown. And our pattern and practice historically is to stay within the election code.
But Marnie,
if you're not registered at the address shown, we cannot, we are not at liberty to decide whether or not the person had enough time to complete the address. We are not at liberty to decide whether or not they wrote the wrong address at that time because they were rushing or they were on their way somewhere. We can't make any of those assumptions. The objection is not registered at address shown.
But Marnie, am I correct that the write-up of this shows that those two signatures were rehabilitated through the use of affidavit?
That's correct.
Opinion?
That's correct.
Okay, thank you. Thank you, Member Watson.
But the affidavit does not say that they are registered at the address shown. The affidavit shows that they are registered at a different address, not at the address shown on the petition.
And I would
now, is this these two signatures that did get rehabilitated? Did they live at that? Were they registered at those addresses?
So there was nothing brought into the record to say that they were not registered at the street name and the address number, except that one signer omitted a digit and one signer had a digit that was a little bit tricky to read and could have been read as a couple of different possible digits. So
that means that they were not registered at the address shown.
Again, they
there's evidence that an omission was made. There's no evidence that an omission was made.
Yep, Mr. Chairman.
Yes, go ahead.
I can just add to the mix. I think Member Watson makes a very good point. The law seems to be clear on its face that you must be registered at the address opposite your name set forth on the petition. But I'm also sympathetic to what Member Cadigan says. I mean, I think when the statute and the supporting case law line up in favor of ballot access, that's the side on which we should err. And I think in this case, I'm inclined to do that. But I have a question first. With respect to the affidavits of Masterson and Patel, the two that Marnie, you differ with the hearing officer on, is there some evidence in the record supporting the attestations in the affidavits?
There is not, although Mr. Mastrangelo has referenced a voter list. There was never actually a voter list put into evidence here. However, Mr. Morphew could have requested a subpoena for the board to get these individual voters' records, and he did not do so.
But is it his burden? I mean, it shouldn't be.
I understand that argument. But an affidavit is something that shows by the preponderance of the evidence, the contents thereof. So if we were on a beyond a reasonable doubt standard, I would say that an affidavit is not enough. But here we're on a preponderance standard. Our rules do not say that a certified voter record is required. Our rules actually say that affidavits are sufficient. And here, by a preponderance of the evidence, and in a way that is uncontroverted, it does show that the voter is registered at the address absent the one-digit issue.
Yeah,
So the voter is not registered at the address shown.
But I have served as a hearing officer back in the day on cases where sort of the affidavit cures, to the extent that there's a question on a signature, an affidavit kind of clears that up and permits a finding that the voter sort of cured whatever technical defect there is on their signature.
Let me be very clear. I don't know how many years you served as a hearing officer, but I did in excess of 35 years in the area of election law. If you are not registered at the address shown, that is a valid objection. An affidavit, which is then submitted, which does not show that you are registered at the address shown, does not rehabilitate nor cure the original objection.
Well, you got me on the 35 years, Member Watson. The only thing I've been doing for 35 years has been a Cubs fan. So,
May I make
Well,
one comment, please?
I'm going to ask Ms. Malowitz.
I'd like to. Member Hain has I think wants to be recognized.
Go ahead, Member Hain.
What we have, I think, is an ambiguity. And that allows us to go with the council's recommendation, although I have a high regard for the experience of Member Watson, especially her breaking that log jam with the county clerks last meeting was very brilliant. But I think we have an ambiguity and we can decide.
How is it ambiguous? Member Haynes, please tell me where the ambiguity is.
You have as Councilor Mastrangelo, is that how you say your name, sir?
Yes, Mastrangelo, that's close.
That's a fine Irish name, yes. We have it because he has established they all live on the same block.
That has nothing to do with it.
Well,
but
yes,
you see, that has absolutely nothing to do with it. The objection is not registered at address shown. The issue is, are you registered at the address shown? Not are you registered. See, the objection is not, the objection by the objector was not an objection which said not registered.
Well,
we all agree that the signer is registered. The objection was not registered at address shown, which is a valid objection.
Except if an ambiguity, there is a preponderance created, as counsel said.
But there isn't any ambiguity. The petition is correct. They are not registered at the address shown. Rehabilitation cannot be done by saying that you live at a different address. And I'm going to let it go.
Well, I am confused. I know it's come down to 2 signatures. And I wouldn't want to throw someone off for 2 minor Scrivener errors, because I agree with Member Cadigan that I think, ballot access would prevail. But if those 2 signatures are being thrown off because they're not registered at their address, then I agree with Member Watson. So are they being thrown off just because of a Scrivener error that was cured by an affidavit?
Yes.
Or yes?
I think it's that simple, Chairman.
Please may I address the board?
Yes.
let me give you an example of why this is the
You have to
5190 is a
identify,
Scrivener's
sir,
error.
I'm sorry, sir, you have to identify yourself. We're on a Zoom, and are you the candidate?
This is attorney, I'm the candidate's
Oh, you're the
attorney,
attorney for
Vito
the candidate.
Mastrangelo.
Yeah, go right ahead.
Yes,
then.
sir. With respect to the 519 versus 5190, let me try to clarify by giving an example. If the street name had been misspelled, would you not consider that to be, an ambiguous Scrivener's error that could be corrected by affidavit? So why is a different standard being used for the number? Obviously he says he is registered to vote at 5190. He says he signed a petition on that sheet. It's clear that he made a Scrivener's error and miswrote his street number, the house number. So it's the equivalent of a misspelled or a missing letter in an address that is corrected by an affidavit. And I believe that this is really a question of being in compliance with the statute requirements for a signature line. Over.
Well, let me ask you this. If it's a Scrivener's error and you corrected that corrected address is where they're registered to vote?
Oh, yes. The final point is that
it really is a Scrivener's error issue.
That name and that address.
No, it's not a Scrivener's error issue.
Why is that, Cassandra? Why is it not?
You see, the statute requires that the signer be registered at the address shown. Scrivener's error has never, to my knowledge, and I have asked our general counsel, been allowed in that type of an objection. Now, that's just the fact. You can't decide. You cannot decide. Does the board, I would say to board members, if you start deciding that everybody who writes their address writes it incorrectly because of a Scrivener's error, that's a problem. This cannot be looked at as a case in isolation. And I would simply, say that.
Thank you. Thank you. All right. Who else wishes to be heard or has questions?
Mr. Chairman?
Yeah, Member Hain.
I just want to add that I spent 40 years taking my petitions around, and I live in a district with many elderly that are frail, and they have a difficult time making out these addresses. And I think it's important for us to find with them, allow them to make a mistake. It's a common thing, really. And you construe this based upon all the facts which Counselor has raised for the candidate. And it's, I think that the affidavit raises the preponderance test, which is what counsel says. And I have to agree with Mr. Cadigan.
And let me just say that once you have your signatures, and in all the years that you went through this process, you check your signatures and the addresses before you submit them. And if you find that an elderly person has inadvertently omitted, then your circulator goes back and has that person to correct their address before you submit your petitions.
Mr. Chairman?
Member Cadigan.
During the discussion here, I just did a quick check, and I did find case law from 1995. Appellate Court of Illinois, First Districts, used the concept of a Scrivener's error to hold that a technical deficiency was sort of harmless. And it's the cases Mullen versus Jacoby, 653 Northeast 2nd, 1303. Case that comes out of an area that I'm familiar with in the northern suburbs, and followed the case at the time. And so as this discussion was proceeding, it prompted me to look for that, and I found what I believe would be some good authority So,
Does it have to do with an address?
No, it just has to do with generally with an error.
Right. A Scribner's error is not an address.
Okay. Well, I'm ready. I'm.
All right. Well, yeah, I think we have a good discussion and a legitimate disagreement, but I think it's pretty clear that the signer was trying to go for the correct address, and
there is no
it
evidence.
was legible enough. I'm sorry?
There's no evidence that this is a Scribner's error. So that's being inferred. And I would also draw the board's attention to a third affidavit that was ruled by the hearing officer, that was ruled admissible, where the individual was able to rehabilitate their signature just by their own word. Their own word now trumps the board's records. And I think that's a dangerous precedent too.
But there was no board records and evidence at the Rule 9 hearing.
I didn't know that. Well, I mean, the deadline for subpoenas had passed, and it would have been rebuttal evidence, and that's my burden.
The rules do have a separate provision for subpoenas relating to Rule 9 evidence.
Understood. They did not meet their burden on that initial proffer, where the evidence is simply lacks foundation. This individual, there's no establishment of how this individual knows the facts that underlie what they're attesting to. So that affidavit should be disregarded as well.
All right. Thank you, Mr. Morphew. You wish to be heard again on behalf of the candidates?
Mr. Chairman?
Yeah, Member McGuffey.
Yes.
Member McGuffey? Well, let's go ahead and hear a final rebuttal from the candidate, and then we'll vote.
Yes, Attorney Morphew mentions that there was no evidence about the foundation, but I pointed out to the hearing officer that the statutes of the election code require the board and election authorities to inform a voter of their registration status.
Anyway,
go ahead, sir.
And so a registered voter, it has the information as to whether they're registered or not. The election authority cannot change a registered voter's status without notifying them. So to suggest a voter doesn't know whether they're registered or not is just a frivolous argument, sir. Over.
All right,
I'd like to be heard on that issue with respect to whether or not a person knows. But Mr. McGuffey, go ahead.
Holding down the button here. Oh, the only thing people that live on the same block, I think you can reasonably assume that they know where they live. The thing that's really concerning is when the signature doesn't match, but an address, that there's one here that where the guy forgot to add a zero after he had a four-digit number, and he only put 3 digits down. And then his affidavit corrects that and adds the 4th digit. This kind of thing is de minimis to me. How many signatures are in question here? Are we, registered at the wrong address? How many are in question altogether?
I think it's come down to 2.
Anybody there?
Yes, it's 2. 2 addresses.
Did you get that, Bill? With the 2 rehabilitated?
Address, I think these really aren't that concerning. I don't only the signature. If the signature matches, and someone leaves a digit off the numerical address, and they all live in the same block. I think Bill Cadigan is right. I mean, this is a question of ballot access, and this is a substantial compliance.
All right, thank you, Member McGuffey. Member Watson, you wanted to be heard one more time.
I wanted to go now to the invalid or validity of the rehabilitation. There apparently are 2 signatures that were rehabilitated, and they were rehabilitated by affidavit. Is that correct, Marnie?
Yes, that's correct.
And how were they rehabilitated? What was the objection? What was the objection in those 2 matters?
Off the top of my head, I'm maybe the parties can weigh in. I'm trying to recall.
Registered at address shown.
That's correct.
Because they'd omitted a digit or whatever the small error was in the address.
Okay, so let me just understand. Perhaps, then, so there are only 2, and both of these 2 have to do with not registered at address shown.
Correct.
So we're not talking about 4, Marnie, is that correct?
So
we're not talking about 4.
We are talking about 4 if you consider the 2 that I am recommending being rehabilitated, along with the 2 where I agree with the hearing officer's recommendation that they be rehabilitated. So at the end of the records examination, the candidate was down by 4 signatures. The hearing officer found that 2 of those signatures had been rehabilitated, and I'm recommending that 2 additional signatures be found to have been rehabilitated by affidavit.
Okay, thank you.
Thanks, Marnie. Thank you, Member Watson. Are we ready to vote? Is there a motion regarding the general counsel's recommendation?
I move adoption of the general counsel's recommendation, finding that the candidate provided evidence of sufficient signatures to be placed on the ballot.
I'll second.
All right, motion made, seconded. Roll call, please.
Mr. Cadigan?
Yes.
Ms. Donahue?
Yes.
Mr. Hain?
Yes.
Mr. McGuffich?
Yes.
Ms. O'Brien?
Yes.
Ms. Watson?
No.
Vice Chairman Lineberry?
Yes.
Chairman Scholes?
Yes. All right, the objection's overruled. The candidate will be on the ballot. Thank you.
Thank you.
Excellent
Thank
article.
you.
Yeah. All right.
Mr.
Bruce?
Chairman, may
Yes.
I make a quick correction to the record? It was
Yes.
brought to my attention that in case 20 SOEBGE 504, I had mistakenly said that candidate Redpath was an independent candidate. He is not. He is a libertarian candidate, and I apologize for my mistake.
Okay. All right. That's noted. All right. And then agenda item T.
Stephen K.
Jr.
Bannon
versus
and
West 20 SOEBGE 508. The objector is represented by Pericles Abbasi, and the candidate is represented by Scott Erdman. The objector filed an objection to the nomination papers of candidate West on the basis that the candidate did not file the minimum number of signatures, as those he filed contained material defects. He failed to name a vice president in his nomination papers, and the candidate's statement of candidacy was allegedly not properly notarized. The candidate filed a motion to strike and dismiss. A records examination was conducted and resulted in the candidate having 180